Matthias, I should say, in case everybody knows who he is, I'm sure that's not true. He is a professor at the University of Vienna. He is a private international specialist, but he also writes on regulation and all kinds of financial law, and has been heavily involved both in the Unidroit project and the A project I mentioned before, and all kinds of other things as well. Venetia is Kerry Boxley, I've got that right, yes. And she was very, very involved in our project on intermediate securities. She writes and thinks about and obviously practices in all areas of financial regulation, particularly securities regulation. And I've asked her to comment on what this will say. So Matthias, would you like to give your presentation?
Yes, thank you very much, Louise, for this very kind introduction. And I apologize for not being in Oxford. I would have loved to be there, but yesterday was my mother's 80th birthday, and I'm here for a birthday party in Germany. If it would have been the 79th, I would have been in Oxford, but it's the 80th. So I hope you understand that I couldn't come. I also apologize that I have to present what seems to be a very dry topic, but I try to make this as interesting as possible and also as understandable as possible. I hope you can see my slides, and I'm going to start the presentation. So MiCAR, you will have heard about it, but nobody knows really something about it because it's rather new. It's a rather complex and long text. So I will briefly describe the aims and methods, the scope, and really briefly the content. But I will also address the question, which is so far rarely addressed, whether MiCAR has some impact on private law, and then I will give an assessment. So MiCAR is a text. It has 166 pages in the official journal of the European Union. If you remember this from the time before Brexit, it's really huge pages. There's a lot of content that you can put on 166 pages. And they have also put a lot of aims into this that partly are incompatible. They want to protect investors and smooth payments and secure financial stability and all of this. And that's why they regulate the crypto market. But at the same time, they also want to promote the crypto industry. And the idea is that by giving a safe and certain legal framework, you would somehow promote this. And to do this, they use techniques that we know from regulation, for instance, transparency and disclosure, registering issuers and service providers such as custodians or people giving advice on this. But then also something that we know from banking, capital requirements, then of course, governance and conduct regulation, redemption rules. Interestingly, we know from investment funds, rather recovery plans are rather typical for banks, and then we have lots of prohibitions and liability. So a wild mix, if I may call it like that. What is this framework actually applied to? It applies to crypto assets, and the MiCAR defines them in the way that I put it up here. And interesting in this definition, it is that they refer to specifically to distributed ledger technology. So contrary to what Louise and others have done at Unidroit, drafting it in a way that is technologically neutral, they refer to a specific technology, to DLT technology, but they say, or a similar technology. Then, of course, that raises the question, what is a similar technology? And we hope that the Commission will clarify this for us. Importantly, they also exclude a number of things from the scope. They exclude, for instance, NFTs, but again, with the counter exclusion, if they're part of a series, then they're covered. But most important is probably the exclusion of financial instruments. So the idea here is when a crypto asset is a financial instrument, for instance, a share, a bond, a derivative, it is not covered by MiCAR because it's already covered by financial law. Deposits like bank deposits are not covered, and a number of things more. And then in the preamble, rather hidden, other things are excluded. For instance, the whole area of DeFi, of decentralized finance, and all crypto assets with no identifiable issuers, which already created the question, is Bitcoin falling under that? Because we don't know who the issuer actually is, possibly. So what is actually covered? Certainly within the scope of MiCAR are the vast majority, a number of payment tokens, utility tokens, and stablecoins. Stablecoins are even at the center, as we will see. But then everything that has an investment purpose, investment tokens, but also hybrid tokens that are between investment and payment token that have both functions, they are covered by traditional financial law and not by MiCAR. And that makes this dividing line extremely important. And we don't know exactly where this dividing line is to be drawn. What distinguishes really a payment token or utility token that has some investment aspects from an investment token that has some utility attached to it? That's unclear. And ESMA, European Authority, has been charged with clarifying that, but only until the end of this year. Then non-fungible tokens are outside, but as insofar as they are part of a series, they are inside. So territorially, the issuance of these tokens and their public offering, but also their admission to trading, it means that trading on the crypto exchange in the EU is covered, and crypto asset services to the EU, to residents of the EU, are covered of these crypto assets, except if the EU resident goes themselves abroad, for instance, by using a VPN and acquiring them from a provider in, let's say, Hong Kong or Singapore. What are the rules? So I gave you here the table of content of MiCAR, and you see clearly at the heart of it are two things called asset reference tokens and e-money tokens. These are two different words for stablecoins, and I will explain in briefly afterwards in what they are different. But they are at the heart of it. These are the highest number of provisions are spent on these two assets in Title 3 and 4. Interestingly, you see that this is the center of it, because Title 2, the starting title in some sense, is entitled Crypto Assets Other Than Asset Reference Tokens or E-Money Tokens. So it's really, this is the catch-all category, and it's drafted in a rather clumsy way, makes also the reading of the whole regulation very difficult, because always when they mean the general tokens, they say crypto assets, the other than, and then this mouthful of other tokens. So the focus here is really on stable coins. The other ones that are governed by Title 2, it's a huge chunk of the realm of crypto assets are cryptocurrencies, utility token, payment tokens. All of these are other crypto assets, and there are very few provisions on them. But then the bulk are on ART and EMT. ART being, or let's start with EMT, it's easier to explain. EMT are those tokens that refer to a single currency, right? Like the euro, but it can also be a third country currency like the pound sterling. And asset reference token are all other stable coins. That means stable coins that may refer to commodities, to real estate, to indices, benchmarks, but also to a basket of different currencies. These are all called ART. And why is the difference? I will show that on the next slide. Why do they make this difference? So they start with, let's say, the other tokens. And this applies, but this applies to all other crypto assets as well, even to stablecoins, means the issuer always has to be a legal person. There are certain rules on marketing communications, and there are rules on the white paper that you have to draw up when you want to issue these assets. For ART, the first type of stablecoins, in addition, the issuer needs to be established in the EU. Needs to be established in the EU. Doesn't suffice to have a branch in the EU or something like that. It needs to be an EU entity. It needs also an authorization to issue these stablecoins. And there are rules on the asset reserve, There are further rules on, for instance, the prohibition of interest. You cannot promise any interest on them. There are also rules on the redemption rights of the investors in these. And now, why is EMT treated differently? The e-money tokens, well, because there was already previously the so-called e-money directive of the EU. And MiCAR just refers to this and says, well, this is similar to e-money. If you refer to just one currency, this is similar to this old e-money directive, where you have on your credit cards, you often have these microchips, and where you can store money that you have previously deposited with a bank. And they say, well, if you have a token that references a specific currency, we submit you to the same rules as these e-money issuers. And that has several implications. One is that only credit institutions of the EU or e-money institutions that have a special license in the EU that are not only established in the EU, but also have this license as credit institutions or e-money institutions can issue these. And then the rules on the e-money directive apply that again have rules on the asset reserve and the redemption rights and so on. So structurally, the end result is very similar. It's a little bit tighter, the straitjacket that we have there. Then there is a second level, or already a third, it depends on how you count it. If ARTs and EMTs are significant, then additional provisions kick in. What means significant? Well, the regulation puts there 7 different criteria, out of which 3 have to be fulfilled. But for instance, to give you an idea, the number of the holders of the token must exceed 10 million, or the value of the token 5 billion euros. And these are 2 of the 7 criteria that lead to an ART being significant. And also this supervision then changes from the national level to the European level. But then the most interesting provision for me in the whole regulation is concerns the so-called super significant stable coins. Well, super significant is not a term that the regulation uses. It's a term that I have invented because there is no name for it. These are ARTs and EMTs that reach a number of transactions of more than 1 million and a value of transactions of 200 million per day. And at that point, you have to stop the issuance of these stable coins, and the issuer has to submit a plan to the to EBA, to the European Banking Authority, how to reduce the circulation of these stable coins. So very strict cap, right? And there is no way to get around this cap. Over a certain threshold, stable coins are not allowed in the EU, and the purpose of that is, of course, to preserve what they call monetary sovereignty, to preserve the role of the euro and the other currencies of the EU, that they will still be the main means of payment in the EU. The ECB, the European Central Bank, has been very strong behind this. Other interesting provisions. So on the white paper, we have rules that you have to put in certain information on the offerer, on the issuer, on the project itself, on the crypto asset, and so on, and even on the adverse impact on the climate of these assets. We know that the proof of work mechanism can result in a waste of energy. You have to disclose that. And again, for the stable coins, additional information is necessary. And then we have a very strong regulation of the crypto asset service providers. Just to give you some examples, those, for instance, the different types of crypto asset services that are regulated. For instance, if you suggest to act as a custodian or administrator of these assets, you have to fulfill all of these requirements that I have listed there. Also, another crypto service would be the operation of a trading platform. So what we call a crypto exchange actually also needs a license and is submitted to very specific regulatory rules. Now I come to the private law content, and that may be rather surprising, but MiCAR, although it is geared towards regulation and mainly contains regulatory rules, also has some express private law rules. For instance, and that is really surprising, it has a rule that when you buy a crypto asset, you have a right, whether you are a consumer or not, doesn't matter. Every purchaser of a crypto asset has a right to withdraw from the contract within 14 days, right? This seems to be inspired by consumer law. We have this right of withdrawal in many consumer law directives of the EU. But here it's, first of all, it's in a regulation. It means it's directly applicable. And second, it's not tied to the purchaser being a consumer. There's certain exclusions, but it's quite far-reaching. Then we have also in a regulation that means uniform on a European level, a liability for the white paper. We have in the prospectus regulation, we have some rules on liability for false prospectuses in the securities area, but we have never achieved a uniform rule on liability for financial instruments. We have it here now for crypto assets, and that's again rather surprising. And then also we have a liability rule, a uniform European liability rule for the loss of crypto assets, a rather strict liability. Now, an interesting question is, do we have, beyond that, do we have some implicit rules on private law? And there I give you an example of a provision that concerns all crypto asset service providers. We call them CASP to make it easy, that shall make adequate arrangements to safeguard the ownership rights of clients. That they have written that into the regulation. Problem is, ownership has a very specific private law connotation, hasn't it? And it doesn't square with the laws of many member states. For instance, Germany, my native country in which I am now, doesn't recognize ownership rights in crypto assets. So what does this actually mean when MiCAR says you have to safeguard the ownership rights of clients? What do they mean by that? Does this mean that these member states who don't recognize ownership in intangibles now have to change their law? Is it a mandate or even a requirement for private law reform? Or does it mean that if you are a CASP, a crypto asset service provider in Germany or in Croatia or in Greece or Hungary, that you should choose the law of another member state that recognizes such ownership rights? And is that even possible? Or in which other ways shall you conform with the requirements of Article 70 if you are sitting in one of these countries? Totally open question. And I'm not sure that they even knew what they did when they wrote the word ownership in there. We can have a discussion about that because these were regulators. Now I'm tying this to Alex's presentation on private international law, because 5 articles down the line, MiCAR says that the crypto assets held in custody, this is a special custody rule, shall be legally segregated from the CASP's estate in the interest of the clients of the crypto asset service providers in accordance with applicable law, so that creditors of the CASP have no recourse especially in the event of insolvency. Again, this raises a question because they use this term like very lightly, in accordance with applicable law, without saying what is actually the applicable law to segregation. How do you determine whether the assets of the custodian are properly segregated from those of the clients? Is this the law of the insolvency proceedings that determines whether they are segregated? But we don't know whether these proceedings will be open. Or is it the lex situs of the crypto assets? But what if the crypto assets are held in several states, or where are they held at all? Right? We don't know that. Or perhaps is it the law of the custody agreement that determines also the segregation, which would then have an incidence on the proprietary rights and also the treatment in insolvency. Final example, in the annex, MiCAR sets out a number of information requirements that you have to put into the white paper. And it says, with regard to stablecoins, you have to inform the public about the law applicable to the crypto assets as well as the competent court. Well, after hearing Alex's presentation, you know already that these are highly contested issues and nobody knows actually what is the law that applies to the crypto assets as well as the competent court, especially in the EU context where we have 27 different national conflict rules when it comes to proprietary rights. So what do they actually mean here? Do they mean the law applicable to the rights embodied in the crypto asset? For instance, if you have a utility token, the right that is embodied by this, or do they mean really the proprietary situation where we don't have a rule? In both, actually, we don't have a rule. So again, I'm just asking here, what does this mean for private international law? Does this really presuppose that we have to regulate it, or does it regulate it implicitly, these questions? My assessment, I think the MiCAR contains a hodgepodge of different regulatory elements that are taken partly from financial law, banking law, payment service law, investment law, even consumer law, and they are stacked on each other, on top of each other. And even additional new things have been invented that have not been there. And that creates, of course, a risk of over-regulation. And I have, at a previous conference in Frankfurt, I have compared MiCAR to MiCAR, and it flew well. I hope it flows well. It flies well here as well. So this is MiCAR, and this is MiCAR. And what are the similarities? Well, you put too many things in the same thing, and it doesn't work well. It just doesn't look well. If you put a little bit of investment law, a little bit of payment law, a little bit of consumer law, a little bit of banking law into something, and you construct it from these different parts, well, they usually don't work too well together. The design is not clear, the aims are not really clear. And what's even worse, you don't cover many things that already exist. For instance, DeFi already existed, or assets without an identifiable issuer. So at the moment when MiCAR came out, already the first articles appeared saying we need MiCAR 2.0. The defects of MiCAR are, one of the main defects in my view is it violates the idea of technological neutrality because it regulates a specific technology, DLT, and of course it says, and similar technologies, but the regulator will have to play catch up with the market and inform us all the time. The next technological wave, what of this is covered by MiCAR and what of is not? Then the assembling of different regulatory rules into one text and applying all of them, throwing all of them at crypto assets leads to heavy bureaucratic burdens on these issuers, contrary to what the regulation suggests. We want to promote the technology. I think it rather kills them from the outset, and I don't see really that how a really important global player in the crypto industry could arise in Europe after this. It pursues conflicting policies. On the one hand, it makes stablecoins, for instance, much more interesting as an asset for investment because it provides all of these protection rules for investors, the asset reserve, for instance, the redemption rights. But on the other hand, it puts a strong cap on it and says, if the stablecoin becomes very successful, then it's prohibited, okay? Then stop it. So what is it? Do you want stablecoins or you don't want them? And what I criticize perhaps the most is it puts a fence around the EU. Only issuers of stablecoins that are established in the EU, that are incorporated in the EU and have their real seat in the EU, and that even have one members of the board must live in the EU. I've never seen anything that is so protectionist and so reclusive as MiCAR, it really creates this fortress Europe, because it doesn't allow any other issuers from Hong Kong, from New York anymore, even if they have absolutely equivalent rules, or even if they comply fully with the European rules, they're not allowed. Same for crypto asset service providers, must be from the EU, can no longer be from a third country, even if they have an equivalent rule, or even if they abide word by word with the EU rules. And then I also think it's built on false premises, because it believes somehow that customers would be the owners of crypto assets, but they're not under all member state systems. So my conclusion is that it's not well thought out. That is also unlikely to reach the goal that is the purpose of crypto assets: facilitate the financing of tech startups. That's what they were invented for. I hardly see how with this regulation you would achieve that aim. And generally, I don't believe that with such a regulation you would catch up with Silicon Valley just by putting 166 pages in the official journal. You don't change the position that you have in technology. And what I also think is, to make the whole thing work, you need at least a bit of private law harmonization, or at least private international law harmonization. So I have put all of this into an article that has now already appeared. It says forthcoming, but it has now already appeared in the Common Market Law Review. If you want to have a look at it, please just use the QR code. Thank you very much.